question from the audience. David, this is for yourself. Are there any other states following California's path in the development of a GDPR-style data privacy law or laws?
Thank you. Good question. So there are certain CCPA-like bills. Proposals in Washington and Texas did not pass. However, Nevada has passed an online privacy amendment, and there are proposals in New York and DC that seem to be gaining some momentum. But overall, we're still in a dynamic, fluid situation. So it's something to keep your eye on.
Thank you so much. And Gavin, how will the statutory damages under the CCPA be calculated?
Well, that's a good question, and it's something that will become more clear as the case law develops. So for now, the best guidance that we have about how the statutory damages will be calculated is by looking to the factors that the statute directs courts to consider and keeping in mind that those are a non-exhaustive list of factors. And I think by looking to those factors, we can get a sense of what courts might find are important and how that might weigh into the range of statutory damages that they might impose, but it's something that we're just going to have to take a wait-and-see approach.
Thank you so much. David, another question for yourself here. What do you think the status is, or what is the status of a comprehensive data privacy legislation, perhaps at a federal level?
That's a tough question to answer. It's really speculative at this point. There are a number of pending bills that vary in scope. They would all subject violators to some type of FTC-imposed penalties. Some examples are there's something called the American Data Dissemination Act, which was introduced by Senator Rubio. There's the Social Media Privacy Protection and Consumer Rights Act by Amy Klobuchar. There's a few more. The Information Transparency and Personal Data Control Act was introduced by a representative from Washington State. So you have various bills, but none of them have received formal committee action, and they probably won't move forward as a standalone bill. So it's something where there is a lot of activity in Washington, but there is still so much, as we all know, there is so much partisan tension. So even though we have seen some support for federal legislation from Democrats and Republicans, and even from some major industry groups and companies, you know, the devil's always in the details. So it's just something where, again, we'll have to wait and see.
Thank you so much, Sagi. We've got a question here for yourself. What should companies inventory when preparing for the CCPA?
That's an excellent question. There are different types of inventories companies should maintain. The most obvious one is, what data do I keep? Where do we keep this information? But they should not be stopping there. Companies should also be inventorying the data subjects, the people that they have, the actual identities that they are responsible for. And most important, for the comments I was making earlier about disclosure, maintain an accurate list of the business partners and vendors that receive personal information from them. If they don't want to have it done comprehensively, at least know which third parties receive California consumer information and GDPR impacted identities. But knowing those third parties and understanding what they do is a big issue. Not only that it's difficult to do and an important chance to take, but again, a reminder to all of us, it's the reason why the sharing of information with third parties is why we have a regulation like CCPA today to contend with in the first place.
Thank you so much, Sagi. Another question for yourself, but our fellow panelists are welcome to chime in as well if they would like. But Sagi, how do companies associate Californian consumers with the purpose of which their their personal information or their data was collected so they can also control its use?
Another very good question, and one that we don't have a good answer for in the market. This is yet another dirty secret that we keep as companies. We don't really know under what pretense and what some of the information that we have about people was collected. We don't necessarily know under what privacy notice or version of privacy notice we received some of this information. And all companies have plenty of data subjects in their systems that they can't necessarily associate with one or another activity and know not to do something with that data. There are some different methods companies are now trying to find this out. One way that is not that is partially efficient is associating a purpose with an application. So very quickly, applications are the front end of a database. Database can the information in a database can fuel, so to speak, many different applications that use parts of it for different purposes. Applications usually have a purpose, but unfortunately, many organizations don't have one or narrow purpose. Give you an example. There is a common application out there called Concur. Concur is used to process employee expenses. That's a good example of a way to associate a person with a particular purpose. If I know that I have a person in Concur, I can say one of the purposes applicable to this identity is expense reimbursement. However, many other applications out there have much broader purposes. Salesforce, for example, has multiple purposes. SAP would have multiple purposes. So the application piece kind of breaks down in that regard. And what we are faced with is new ways of tagging data that companies today do not have the discipline of doing. This will change, but that's part of the challenge that we need to face together, not just in the privacy office, but privacy with IT and data, so that we can in fact move from just talking about privacy and having nice policies about them to in fact implementing it in day-to-day operations.